Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back on the Rahimi case again because a lot of briefs have been coming in, and I made a little mistake, and the little mistake is I actually read an amicus brief from the ACLU. Someone had tipped me off about that, and I was checking that out, and then I noticed they were getting kind of critical of the United States government's approach to disarming you, even though the ACLU was in favor of disarming you. Got a video coming on that later. And so I decided to, hey, maybe it might be time to take a look at what they had to say in their petition to the United States Supreme Court in Rahimi and why the Fifth Circuit should be overturned. And oh boy, do they have a lot to say. And as usual, you know, the minute they have a chance to take an inch, they will, in fact, try to take a mile. I'm going to show you exactly what they're trying to do. It's pretty nefarious. So today, let's get you all educated and let's talk about another way that DOJ wants to disarm you. Okay, so what we're talking about again is the case of United States v. Rahimi. It is a loaded matter, to say the least. It's going to be for the United States Supreme Court next term. It challenges the constitutionality of 18 USC Section 922 G8, which prohibits those who have been accused of violent crimes, as well as domestic violence and other felonies, from possessing firearms while under indictment. This is pre-conviction. Now, the Fifth Circuit threw that law out on its ass, and the United States government, of course, then appealed to the United States Supreme Court, and the United States Supreme Court accepted review. Think about that for a second when you're trying to play odds maker on this. Now, what I had an opportunity to do is to review this because, you know, at the end of the day, if you really want to boil Rahimi down, okay, and we all know what the law does, and if you don't know more about it, there's plenty of videos that I've linked up down below for you to geek out on, and there's plenty of other people out here in the YouTubeverse that have also done really good videos on it, okay? But at the end of the day, the Section 18 USC 922 G8 was actually passed in 1994, okay? So then the question is there a historical precedent that justifies the existence of a law that was created in 1994 that also was justified back in the late 1700s? Now, I know your gut instinct is there's no way. And we've done a video where it said, hey, there really is no such thing as innovative gun control. And I stand by that, but here's the thing. I'm not too certain that this is particularly innovative gun control here. And we've already talked about how the fact that there is a long, rich, lengthy tradition in this country of disarming groups of people that society deems to be dangerous. Now, granted, the criteria by which they used are regrettable, completely back-ass words and all of that, okay? But that is, in fact, a tradition that actually predates even the Declaration of Independence, okay? Now, one would think, knowing that that's the nice little narrow path that you could create here to try to actually make an effective argument why the Fifth Circuit got it wrong, and knowing that that is exactly the same argument that the ACLU is making in the video still coming on this, one would think the United States would do exactly that, right? But no. You see, because their gun control measures are actually it's like rancid floodwater, okay? It will get into every little crack and crevice and empty space that there possibly is. And what I'm going to show you here in the pleadings is what the United States government has done is they've taken three cases, you'll know all three of them, they then kind of blow out of proportion a couple of words, and then they argue that our tradition of restricting firearms goes far beyond what it actually does. Let me show you what they did. They summarized their argument, and this should come as a shock to nobody, as follows. The Second Amendment does not prohibit Congress from disarming Rahimi and other individuals subject to domestic violence protective orders. And one of the things that, of course, was very successful in the Fifth Circuit was Rahimi arguing that, hey, there is no historical analog for disarming people who are accused of domestic violence. Now, the government had argued quite strenuously that there really was no such thing as domestic violence crimes at that time, which was also true. That did not work. However, the United States government again advances that position here as they state, the Fifth Circuit also noted the laws disarming domestic abusers did not exist at the founding. But this court has emphatically rejected demands for an exact historical match. And that's why I believe that there is an effective argument that we as a society have accepted for many years now the disarmament of certain groups of people that we as a society deem to be dangerous. But instead of taking that very clear path, no, instead what they want to do, rather than take this case apart with a scalpel, which is really the way it needs to be done here, no, instead they want to go in with just a complete bulldozer, okay? And so what they're essentially doing is they're going to take three cases. Let me show you what they did, and then I'll show you how their argument works. In Heller, this court described the right to keep and bear arms as a right of law-abiding, responsible citizens. The plurality in McDonald similarly observed that the Second Amendment protects the safety of law-abiding members of the community. Bruin reaffirmed that reading of the Second Amendment. This court reiterated Heller and McDonald's holding that the amendment protects the right of an ordinary, law-abiding citizen to possess a handgun in the home. But then, by the mere mention of one word in Heller as responsible, the United States government then advances not the historical tradition of being able to restrict those that we deem dangerous, but those that government deems to be irresponsible. Okay, don't believe me? Well, here are some of the quotes from their memorandum. This court's precedents recognize that Congress may disarm persons who are not law-abiding, responsible citizens. History confirms that Congress may disarm persons who are not law-abiding, responsible citizens. The nation has a long tradition of disarming persons who are not law-abiding, responsible citizens. And then going through a litany of other historical precedent, and amazingly, tiptoeing around all the racial gun laws. It's an amazing little square dance that they did to get around it there, okay? But ultimately, what the government concludes when taking a look at the historical precedent is the following. In exercising that authority, Congress need not require case-by-case findings of dangerousness like those required by Section 922G8. Congress may make categorical judgments about responsibility. That some categorical limits are proper is part of the original meaning of the Second Amendment. So you see what they're doing? They're saying, hey, government can restrict your access to firearms, not if you're just dangerous, but if we deem you to be irresponsible. And this is the problem, is that at least with dangerous, we have things called violent crimes. Every state defines certain levels of crimes as violent. Violent misdemeanors, violent gross misdemeanors, violent felonies, okay? It's pretty simple. You don't have to really go to law school to figure out which one they are, okay? However, what is irresponsible behavior? And what is irresponsible behavior when we see in these very blue states where they're going after any type of conservative speech? We're beginning to have parents who just want to go and express their frustration to a school board. Suddenly, they're now being labeled as domestic terrorists. Does that make them irresponsible? And therefore, the government can restrict their access or strip them of their Second Amendment rights. In fact, this is exactly how the government sums it up. The court need only hold that a person is not responsible and thus may be disarmed if his possession of a firearm would endanger himself or others. And then, of course, they make the obvious claim that flows from that, which is individuals subject to domestic violence protective orders are not responsible. And so what you can see here is the government has taken a clearly acceptable historical precedent, which is disarming those that are dangerous, and now trying to overexpand it to anything that is deemed to be irresponsible, and God only knows how they would then want to define responsibility or how a court with a particular agenda could define that. So like I mentioned at the beginning of this video, the government's argument here really is like rancid floodwater. It is going to seep into every little crack and crevice and open space that the court gives them. And what they are clearly trying to do is to get a ruling that says that individuals who are deemed irresponsible by government can be disarmed. That is not the historical precedent. There is a rich historical precedent for disarming those that we believe are dangerous. Granted, the criteria that we used in the 1600s, 1700s, and 1800s is completely ridiculous by today's standards, and it is completely ridiculous. In this case, however, Rahimi is being disarmed because of his alleged actual conduct. Now, one of the things I should point out is I did a word search, and if you don't believe me that they are really trying to shift the argument from one of dangerousness to irresponsibility, well, the word dangerous is actually mentioned 21 times in the memorandum from the United States government. However, the word irresponsible Well, that's mentioned 51 times. Listen, we're going to link it all up down below so you can see for yourself. You guys can be the judge. You can make comments if you so desire. In the meantime, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. But if you don't, that's okay. That information is right down there in the description box. Now, in the meantime, I need you all to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.